There's an adage in the legal profession: hard cases make bad law. It can also be said that bad cases make bad law. And the case of United States versus Rahimi is one of those bad cases. The question is legitimate. Does 18 U.S.C. section 922 G8, which prohibits a person under a domestic violence restraining order from possessing a firearm or ammunition, violate the Second Amendment? Now, for those of you who are thinking the answer is yes, Zackey Rahimi is not the person you would want leading this case. So we'll discuss this case next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your and generation be free. I'm glad you could join me today. You know, the Rahimi case, I've been watching it in the Second Amendment community pretty much since it was first petitioned to the Supreme Court for certiorari. And it's one of those things where, gee, I wish we had a better case. But we dealing with the case that we actually have. And I want to get into some of the details, some of the good, some of the bad, maybe some of the ugly. Now, if you want to find out more, if you want to check out the resources I used, we'll go to constitutionstudy.com, and I'll include the links for all of my references. You can find the article and so much more. I'll talk a bit more about the website at the end of this episode, but for now, let's take a look at this Rahimi case. Federal limitations on gun possession have been a sticking point among the Second Amendment community for decades. I know several groups and law firms that have been looking for the perfect case to challenge some of these laws. Instead, Zackey Rahimi got his case to the Supreme Court first. Respondent Zackey Rahimi was indicted under 18 U.S.C. section 922 G8, a federal statute that prohibits individuals subject to a domestic violence restraining order from possessing a firearm. Now, Zackey Rahimi was indicted under section 922 G8, meaning he is accused of possession of a firearm while subject to a domestic violence restraining order. This law requires that several conditions are met regarding the restraining order before Section 922 G8 can be enforced. In particular, the order must either contain a finding that the defendant represents a credible threat to the physical safety of his intimate partner or his partner's child, or by its terms explicitly prohibit the use, attempted use, or threatened use of physical force against those individuals. Now, based on that, the first question that needs to be asked is, did the restraining order against Mr. Rahimi meet those requirements? Rahimi concedes here that the restraining order against him satisfies the statutory criteria, but argues that on its face, Section 922 G8 violates the Second Amendment. Even Mr. Rahimi concedes that the restraining order against him meets the requirements of Section 922 G8. However, he contends that 922 G8 facially violates the Second Amendment. Now, there's a bit of a twist to this case, though. The district court denied Rahimi's motion to dismiss the indictment on Second Amendment grounds. While Rahimi's case was on appeal, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin. After the district court denied Rahimi's motion, the Supreme Court decided New York State Rifle and Pistol Association v. Bruin. This is important because in Bruin, the court stated that a law that falls within the text of the Second Amendment is unconstitutional unless there is evidence that it fits within the traditional firearm regulations at the time the Bill of Rights and the 14th Amendment were adopted. This led to a different decision by the Circuit Court. In light of Bruin, the Fifth Circuit reversed, concluding that the government had not shown that Section 922 G8 fits within our nation's historical tradition of firearm regulations. Which brings us to the decision of the vast majority of this court, the Supreme Court. Held, when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. 8 of the 9 justices agreed with this decision. 6 of those 8, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson, either filed or joined in concurrences. An 8-1 decision is fairly rare at the Supreme Court, even if 6 of the 8 disagree with some part of how the court got to it. Since the founding, the nation's firearms laws included regulations to stop individuals who threaten physical harm to others from misusing firearms. As applied to the facts here, Section 922G8 fits within this tradition. Yes, there have been laws in our nation's tradition to stop individuals who threaten to harm others. But does 922G8 meet that standard? Rahimi's facial challenge to Section 922G8 requires him to establish that no set of circumstances exists under which the act would be valid. Here, Section 922G8 is constitutional as applied to the facts in Rahimi's own case. Rahimi has been found by a court to pose a credible threat to the physical safety of others, and the government offers ample evidence that the Second Amendment permits such individuals to be disarmed. Even Rahimi concedes that the restraining order against him meets the 922G8 standard, which includes a finding that such person represents a credible threat to the physical safety of such intimate partner or child. As I mentioned, 6 of the 8 justices either filed or joined a concurrence. Now, while all 6 of those justices agreed with the opinion, noting relatively minor differences in their concurrences, Justice Barrett did make one statement I think worth commenting on. Despite its unqualified text, the Second Amendment is not absolute. It codified a pre-existing right, and the pre-existing limits on that right are part and parcel of it. Even though Justice Barrett notes that the text of the Second Amendment is unqualified, she wants to put qualifications on it. Here's the problem I have with that. Justice Barrett is simply ignoring the text of the Constitution she doesn't like. Yes, the Second Amendment is unqualified, just as the 1st, 4th, 6th, 7th, 8th, 9th, and 10th are. But that doesn't mean there are not situations where an individual cannot exercise their rights. As Benjamin Franklin, writing as Silas Dogood, said, "Without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man as far by it he does not hurt or control the right of another. And this is the only check it ought to suffer, and only bounds it ought to know." The limitations of the exercise of our rights does not extend to harming or controlling others. For example, in the case Schnecht versus United States, the Supreme Court recognized that a person could not use the First Amendment to defend false claims meant to hurt others, also known as the fire in a crowded theater situation. And just as a person cannot use their freedom of speech to harm others, neither can someone use their right to keep and bear arms for such a purpose. And according to Benjamin Franklin, that is the only check it ought to suffer. Now, while Justice Thomas was the only dissenter, his dissent is worth reading. After New York State Rifle and Pistol Association, Inc. v. Bruin, this court's directive was clear. A firearm regulation that falls within the Second Amendment's plain text is unconstitutional unless it is consistent with the nation's historical tradition of firearm regulation. Not a single historical regulation justifies the statute at issue, 18 U.S.C. Section 922G8. Therefore, I respectfully dissent. See, unlike the rest of the court, Justice Thomas says there is not a historical analog to justify 922G8. Just as important as 922G8's express terms is what it leaves unsaid. Section 922G8 does not require a finding that a person has ever committed a crime of domestic violence. As Justice Thomas points out, there is no requirement that a person be found guilty of domestic violence before 922G8 can be enforced. This makes it different than other parts of 922G. It is not triggered by a criminal conviction or person's criminal history, unlike other 922G subsections. And 922G8 does not distinguish contested orders from joint orders, for example, when parties voluntarily enter a no-contact agreement or when both parties seek a restraining order. If both parties seek a restraining order, would said order include a finding that a credible threat to the physical safety of one of the parties? In addition, 922G8 strips an individual of his ability to possess firearms and ammunition without any due process. Rather, the ban is an automatic, uncontestable consequence of certain orders. There is no hearing or opportunity to be heard on the statute's applicability, and a court need not decide whether a person should be disarmed under 922G8. The only process 922G8 requires is that required or not for the underlying restraining order. Now, Justice Thomas says that 922G8 strips a person of a right protected by the Constitution without due process. It's the due process that's important because the Fifth Amendment states, no person shall be deprived of life, liberty, or property without due process of law. While there is no hearing regarding 922G8, the protective order that triggers it does require the person to be notified and have the opportunity to participate in the hearing. Does that satisfy the due process requirement? This case seems to be full of contradictions. On the one hand, we have 922G8, which states that someone who has a court order of protection because of a finding of a credible threat to the physical safety of another cannot lawfully possess a firearm or ammunition. However, even though the subject of the order must have the opportunity to participate in a hearing before the order is issued, there is apparently no requirement that they receive due process during the hearing. They don't have the right to counsel, to compel their accuser, or to compel witnesses in their favor. It is not as if a disgruntled spouse or neighbor hasn't accused someone of being a physical threat without any threat being made. And just how does the federal government get to use the actions of state courts to claim a justification of a criminal statute? Since the Second Amendment prohibits the infringement on the right of a person to keep and bear arms, shouldn't it be the court finding the facts of this case that determines if the punishment is just for the subject? After all, if a judge issues an order depriving someone of a right protected by the Constitution without due process, they'd be violating the Constitution. I'm also a bit disappointed with the case as a whole. Yes, Mr. Rahimi deserves his grievance to be heard. But of all the cases of infringement on the Second Amendment by court order, I would have preferred a less unsavory subject. After all, he did agree that he posed a threat of physical harm to an intimate partner. Now, there are two subsections of 922 I would like to see brought before the court. Subsection 1, who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. There are plenty of nonviolent crimes throughout the states and federal government that are punishable by a year or more of imprisonment. Should someone be deprived of their right to keep and bear arms for being convicted of a nonviolent crime simply because of how long a sentence they could have received? And subsection 9, who has been convicted in any court of a misdemeanor crime of domestic violence. So if someone is convicted of a felony domestic violence, they're not subject to 922? How does that make any sense? Well, part of me recognizes that people who are threatened don't want those who threaten them to have legal access to firearms. I also recognize that does not always prevent the subject from actually having firearms. At the same time, I recognize that the accused is not the convicted, and we have a policy of innocent until proven guilty in this country. Where do I come down on this decision? I would have liked to see a discussion on the constitutionality of the federal government adding punishments to state crimes and court orders. Reluctantly, based solely on the facts of the case, I have to come down with a majority. In the competition between due process and physical safety, our right to life must take precedent. While the temporary loss of rights is an infringement, I think the law strikes a balance by requiring that the accused be able to participate in the hearing and that a judge comes to a finding that they represent a credible threat to the physical safety of another. That said, I'm saddened by the fact that the court order is just a piece of paper and can do nothing to prevent someone found to be a threat from actually acquiring a firearm and, sadly, using it. While not within the jurisdiction of the court, I think 922G, and in fact other parts of 922, have some serious constitutional problems. I see no power delegated to the United States to add federal penalties to state laws, nor to regulate firearms ownership, only foreign and interstate commerce. As I said, bad facts tend to make bad law, and a bad case tends to make bad law. And I think, well, let's just say Rahimi was not the right person to bring to challenge all of 922G. The whole idea of a federal punishment, a federal prohibition for a state action to infringe on a person's right to keep and bear arms because the federal government thinks they're dangerous. Again, looking at a domestic violence restraining order, you've already got an unsympathetic character. Right? Rahimi's not sympathetic because he is accused and even admits that he had a threat of physical violence to a partner. That's not exactly someone that's going to be people want to support. So they're going to find in this case that it didn't violate his right under the Second Amendment. There may have been a violation of his rights under the Fifth Amendment, the Due Process Amendments, even the 14th Amendment's due process clauses, but that's not what was brought. The question is, how much due process, how far must you go in the due process before we can say it is not safe for you to carry firearms? More importantly, does the federal government have the legal authority to say a state court found this, therefore you're eligible for a federal crime? You are now deprived of your right under the Second Amendment because a state court found you to be dangerous, not that it was wrong for you to have firearms. That's the part where I keep kind of going back and forth because I can't find, or at least I have not yet found, a good answer to that. I hope there are other cases that come that look at other parts of 922, even 922G, but I don't know if there are any on the horizon. Now, if you want to find the links to where I got all my sources, we can find the article at constitutionstudy.com. Check it out and double check my sources. And hey, if you've got an idea of maybe, again, the court can't change this, but maybe how the law could be changed to make things better, we might consider that. While you're at it, hey, check out the Patriots program, constitutionstudy.com/patriots. It's an invitation-only program to help people study the Constitution, know what's going on, and then actually act on it. How do we prepare ourselves to defend and assert our rights? And then how do we prepare ourselves to help others prepare to defend and assert our rights? Again, it's invitation only. You have to take the boot camp and sign the oath. But the boot camp's free, and even if you don't go any further, you'll probably learn something there. You can also support us with your cell phone. That's right. Use your cell phone to support the Constitution Study. Go to patriotmobile.com/constitution. The Patriot Mobile is America's only Christian conservative wireless carrier, and it's the only one we got. And if you go to patriotmobile.com/constitution and you find a plan and you sign up, they'll help support the Constitution Study. As an added benefit, if you use the code Constitution at checkout, you'll also get free activation. So check it out. Again, patriotmobile.com/constitution and use the code Constitution at checkout to get free activation. Whatever you do, I hope you'll take this information and share it. Share these videos, the articles, the podcasts, whatever you can. Let other people know that the Constitution Study is out here. Then encourage them and come back and join us the next time we meet for the Constitution Study.